Hi, everyone. This is Xiaochuan Weng. The member of CLNR. Thanks very much for the organizer of the symposium for offering me this chance to share one of my work in progress. Um, the topic is a promising path or dead end director's duties of care in China. Basically, the reason why we are doing this research is we at the moment in China the duty of care is still not very clear, and the law doesn't provide any definition and explanation or standards to explain what is duty of care. This research is trying to solve some very fundamental question that is what is the definition of duty of care in China. Um, why this will become a big problem? Because China is not a common law jurisdiction, which means case or precedents are not binding. The only source for duty of care is we need to look back into the statutory materials to find out what is the duty of care, what is the standard of care. In 1990s, the first version of a Chinese company law provide a definition, a sort of definition of a director's duties. However, um, in this definition, there's no categorization of director's duties. What we can see over here in 1993, the expression only leads to the fact that the law is imposing a duty on directors and want directors to be responsible for their employer. After quite many years later, in the beginning of 2000, when China actively applying the accession to WTO, China has to modify its corporate governance standards in order to receive more credibility in its company law. So in 2005, Chinese law, company law, first time recognize categorized directors' duties. It says the directors, supervisors, and senior managers shall bear the obligation of fidelity and diligence to the company. However, after such expression, nobody knows what is the obligation of diligence, what is the obligation of fidelity. To be sure, the obligation of fidelity in Chinese is exactly the counterpart of the of loyalty. However, if you look into the obligation of diligence in Mandarin, it's quite different from duty of care. There are two different understandings. The first one is people believe the duty of care, obligation of diligence is exactly the same as a common law jurisdiction's duty of care. Another group of people believe that the obligations of diligence is not a duty of care. It just contains a small part of duty of care, which means we only require the directors to work as hard as possible, and it's not involving in independently exercising their discretionary power and taking care of the business of corporations as taking care of their own business. Then in 2018, the existing Chinese company law follows 2005 expression, put that provision into 147, which means in China at the moment, the law doesn't tell us what is duty of care, what's the standard of care. The first step we are trying to figure out what is duty of care in China is we try to look into other regulations, explanatory regulations promulgated by administrative agencies, try to figure out what those administrative agencies believe should be the right explanation of a duty of care. We take a look at the CSRC, Chinese Securities Regulatory Commission's rules and the stock exchanges rules on both agencies are regulating listed companies. They enforcing a company and a securities law and promulgate explanatory rules based on Chinese company law. The first finding we discover after looking into the provisions, the rules, is quite a few rules are confirming a duty of care in China, focusing on diligence. However, we still find several, quite a few rules talking about directors need to exercise a ordinary prudent person standard discretionary power over when they are making business decision. So this shows that in China, the obligation of diligence mentioned in 147 are supposed to be a duty of care, very similar to the common law jurisdiction instead of just the required directors to work as hard as they can. And the second discovery we get from the reading is the rules are not associating duty of care and a duty of royalty. In those rules, they usually mention is the duty of care and the royalty, which is consistent with the expression of 147. This is a little bit problematic. Then the next step we are trying to find out is whether in a practice there are more explanations in relation to duty of care, because from reading those rules, we cannot find too much information. At the same time, we don't find any standard of care from those rules. Then we need to solve two problems in looking into the law in action. The first one is, what does the obligation of diligence in practice, does the obligation of diligence exclude the duty of care? And in practice, does obligation of diligence is of a duty of loyalty and a duty of diligence? In other words, a duty of loyalty and diligence in China, whether it's a singular duty or in a practice we treat them separately. Then the second is other issues of law in action of duty of care in China. For example, whether there's a standard, whether the business judgment rule has been applied in a practice. Then the judicial finding, I'm sorry, I missed the page. The way we try to find out law in action is we investigate within 3 years cases on duty of care in China, in Shanghai. The reason why we choose Shanghai is because we searched the database. Shanghai provided the biggest number of duty of care case, which is around 100 cases in the past 3 years. We need to go through all the cases and tease out the information in those cases. So I think this basically is appropriate for such capacity. And then the second way we find the law in action of duty of care in China is we study recent 3 years punishment decisions by Chinese Securities Regulatory Commission, because Chinese Securities Regulatory Commission having the corporate law power to enforce duty of care on a listed company in China. It punished irresponsible directors for mainly focusing on violation of disclosure requirements, using duty of care as a reason to punish those directors. If the directors cannot prove they have fully fulfilled the duty of care in disclosure cases, they will be punished. Then the co-finding, there are 5 major judicial findings we discovered after reading roughly 100 cases. The first one is majority cases use duty of loyalty and diligence as the tag to describe duty of care cases, which is very, very interesting. And this is also consistent with the expression of Article 147. However, this is problematic. This leads to second finding. Some judges may apply the duty of loyalty standard when adjudicating a obligation of a diligence case. A very interesting case we found was a chairman of a board of directors. When the court cannot prove that the chairman got interest involved in the transaction, the court required the chairman to show the entire transaction is fair, which is in China is a standard of duty of loyalty instead of a duty of care. Otherwise, the chairman will be deemed as the violation of a duty of care. So we can see over here the mix. The name confusion leads to the standards confusion in China. This is the second finding. And the third one is a simple, ordinary, prudent person standard that has been discussed in quite a lot of cases. And quite a few cases also mention the circumstances that the management was in to try to adjust the ordinary, prudent person. However, most of the discussion has been on the ordinary prudent person standard. Why is that? That is because, as we previously mentioned, in China is a civil jurisdictions, precedents are not binding. That means every time judges need to reconstruct the whole empire of proving the ordinary prudent person standard and justify it. So this is quite onerous. At the same time, greatly limited the judge's power to further develop the specifications of a prudent person standards for duty of care cases. And the fourth one we find is when actively assessing a managerial decisions, judiciary seems not worried about second-guess business decisions. Not as all case. We find out of 100 duty of care cases, judge show any judicial constraint not to second-guess business decisions. This is quite different from the UK model and the US model. From legislation perspective or adjudication policy perspective, the judge should not involve into the second guess of business decision. And the fifth one, we discovered more than half of the case about the duty of diligence is about a case is about the duty of diligence is actually about how hard the director was fulfilling their duty. This is quite easy to understand. That is because the law using the diligence as expression, and the plaintiffs and the judges feel much safer when they using the duty of diligence to adjudicating a case, and they feel much confident in litigating under the name of duty of diligence instead of launching a case of duty of care, because the law per se is quite ambiguous. From CSRC's punishment decisions perspective, what we discover is CSRC usually holds directors and senior managers liable for not disclosing mandatory issues because they cannot prove that they have adequately fulfilled their obligation of diligence. Then there's no discussion of the standard of care in any case in the past 3 years of CSRC's punishment cases. And what CSRC interested the most is the director's individual skills. Why is that? After reading so many cases, we conclude that the reason why CSRC is interested in the individual director's skills is to ensure to the punishment or finding the violation, contravention of duty of care in every case, because individual skills for CSRC, it's very easy to say you fail to use your personal skills in fulfilling your duty, then that's the reason why we punish you. But this is kind of very, very different from other foreign administrative agencies' option of a duty of care cases in the securities market. And I believe taking Australian ASIC as an example, a duty of care usually is employed by ASIC with the purpose of establish a better corporate governance standard for the market, instead of just punish individual directors to appease the anger of investors or cover the governance issue of the market regulators. So then we conclude for very preliminary thoughts, we have 3 suggestions. The first one is we believe that duty of care in China needs to be differentiated from duty of loyalty in order to prevent further mixing of using of standards, and duty of obligation of diligence should be properly defined as a duty of care instead of still using it as an obligation of diligence. Then the second suggestion we provide is Chinese judiciary need a clear standard of care, which should be put into, which should be statutorized and put into law, so that a judge can save some effort and then use those efforts to further explain, to enrich the context of the standard of care. Judiciary may also consider incorporated duty of skills in order to properly to serve justice for the plaintiffs, to consider the protection of the corporations. This is because if you don't consider the skills, usually you fail to protect the corporations, because corporations, they usually hire directors and managers for their skills. If you fail to take that into consideration in adjudicating duty of care cases, it seems that the interest of the corporations couldn't be properly protected And the third one is administrative agencies should apply duty of care with a functional purpose, which means CSRC and the stock exchange, they need to be very clear why they are applying duty of care cases, why they are punishing directors. They are not just punishing directors because of the fact that they need to punish them. They are punishing directors because they need to establish a better corporate governance standard for the market, for the whole industry. So administrative agencies need to stick to the standard of care instead of focusing on individual directors' skills. Basically, those 3 points are very preliminary findings of our research. That's my presentation. Thanks for listening.